I don't know. After hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
What's going on? This is Colin. How's everybody doing? Happy Tuesday. Good to see you all. Hope you all are doing well. See the chat rolling. Welcome everybody. Hey, no, Philip, Trish, Nancy, good to see you. Michelle, I saw Jedi earlier. Heather's in the house. There she was. She may have gone to sleep already. James, welcome. Hold on. I just did something weird. I hit a button. Before I get started, Michelle, thank you for the 1 month, and welcome, Nancy. Thank you for becoming a member. Also, on that note, yesterday during my members only live stream, I missed somebody renewing their membership. So I want to make sure to shout them out. I haven't seen their name scroll by yet, so I'm going to say it again when I see their name, but their name is Shane, and I am sorry. I don't know how I missed it. I did, and I apologize. You were absolutely right to call me out in the comments, and yeah, that shouldn't happen, and I do apologize. All right. Now on to some court. Oh, hey Shane. Shane, thank you. Yeah, it wasn't on purpose. It was an accident. I'm generally very good at calling everybody out, and for some reason I missed it. I don't know how I did. All right. Anyways, let's talk about some court. First guy's Judge LaCost. We got a sovereign citizen that kind of excuse me, hold on. That was weird. He bails on his sovereign citizen thing. Kind of, not fully. But yeah, it's a good one. It's a good one. I know I said that I was getting tired of sovereign citizens, but this one's kind of funny. So we're going to play that. That's the first clip. But before I hit that play button, you already know what to do. Hit the like and subscribe. Do your jump kick backflips. Also, thank you so much, Heather, for all the emotes. There's actually a jump kick backflip emote now. Thank you. All right, let's go.
Mr. Peltola, can you hear me adequately?
Yes, I can, Honor. How are you doing?
Good, thank you. How are you today?
Not too bad. Feeling a little rough, sore from being in a holding cell 3 days, but other than that, I'm okay.
All right, let me call your matter so we're on the record, please. People of the state of Michigan versus Drew James Peltola, 247819SM. Mr. Peltola appears from the Dickinson County Jail. Counsel at first appearance is Abby Anderson, who appears via video Zoom. And the prosecution is not here today of their own choosing. Mr. Peltola, before we went on the record, indicated he could hear me adequately, and he was all right other than being sore from being in the holding cell for 3 days. In respect to the matter then, Mr. Peltola, I do have an advice of rights here with your signature. I do see, it looks like the copyright insignia. I know that we have discussed the issue of the sovereign citizen in the past. Mr. Peltola, can you tell me what your position is today, please? After telling me what your full legal name is, if you would.
Okay, I'm appellation known as, all capital letters, Drew James Peltola, with a common law copyright as a sui juris human, as a non-citizen, a not American national. That's defined in the United States Code. I'd like to have my lawyer finish talking. She told me not to talk unless she could talk first.
All right, thank you. Go ahead, Ms. Anderson.
Thank you, Your Honor. I have discussed these matters with Mr. Peltola. First, he agrees to be referred to as Mr. Peltola for purposes of these hearings. We have gone over both the advice of rights for misdemeanor and bond violation. He indicated he understood and signed both. As to the allegations, we went over the maximum penalties. We would waive the formal reading. He is tendering not guilty pleas and requested an attorney. Ms. Mashik-Lasala has assigned Nancy Schaub to represent him.
All right, very well. As indicated by Ms. Anderson, Mr. Peltola has agreed for purposes of his criminal prosecution to be referred to as Drew James Peltola. His position in respect to how he should be recognized legally has been stated for the record and is preserved for the record. as well as stated on the advice of rights form concerning both the general misdemeanor advice of rights. Although the bond violation advice of rights doesn't so indicate, the court will recognize this position for purposes of both advice of rights. Concerning the matter then, is this a good mailing address for you, Mr. Peltola, on River Street?
Yes, Your Honor. I'm just trying to move back into Michigan, so I've been working, and that's the address that I use because that's my domicile. I always return to every day or once a week or whatever. Because the Michigan residents, I'm not even sure. I would not like to talk about that in court, but I'm trying to move back into Michigan. I'm just having a heck of a time doing it.
All right.
Stop getting in trouble, man. It's a lot easier to move when you're not in jail. Also, he's, like I said, it's amazing what a couple days in jail, 3 days in the holding cell. You know what? Maybe this sovereign citizen stuff isn't working. Yeah, he makes a few more comments, but not really. He lets his attorney talk, and yeah, maybe that's what we should do. Just put all the sovereign citizens in jail for 3 days. See what happens.
So this is what I'm going to do then, Mr. Peltola. Over there. Let's see if I have one in my file first. Ms. Anderson, I don't see a waiver of extradition. It sounds like he's going to need to go back and forth to Wisconsin, and we'll address that momentarily. In respect to the matter, though, Mr. Peltola, there is a waiver of extradition form over there at the jail. I'm going to have you sign that if you need to go into Wisconsin as part of this. In regard to the matter, then, what?
How do you want me to sign this? If you want my copyright, do you want me sui juris, just so you understand, like I wasn't trying to harm you or any other woman?
Well, I don't feel
that.
Go ahead. Go ahead. I'm sorry, I didn't mean to interrupt. Go ahead. Go ahead.
Do you want my copyright on this? Do you want me as a human or me as a sui juris non-citizen national?
I just want your signature and the date, and whatever you want to put in addition to that is fine with me.
All right, thank you. Can I have a pen?
I mean, he's already accepted the fact he's going to sign the paper. Why even ask that question? He knew exactly what she wanted. I don't understand why he need to clarify that. But yeah, I guess I don't understand is how I start every sentence when I'm talking about sovereign citizens. So yeah, okay.
Your Honor, while Mr. Peltola is signing that, we did discuss the waiver of extradition. He just wanted that answer clarified prior to signing, but he is aware of what the waiver of extradition is.
Very good, thank you. All right, I'll enter not guilty pleas on behalf of Mr. Peltola. Ms. Anderson indicates that he's qualified and he is being assigned by MIDC. Ms. Schaub, we're going to set bond violation hearing. We might as well do the pretrial at the same time. And a jury trial as follows. Yes, just to be safe.
Okay. Pretrial conference and bond violation hearing on February 21st at 1:45 p.m. Jury trial March 8th at 9 a.m.
All right, you'll get these dates in writing, Mr. Peltola. In respect to the waiver of extradition, then I want to go over it with you briefly as well.
All right, cool. I can wait. You want me to stop filling this out?
Really, all you need to do, yeah, go ahead. You finish, and then I'll go, and then I'll talk. You let me know when you're ready.
I'll just sign it real quick on the bottom of it, and they can take care of the rest of it. I'll sign it properly.
So he knows how to sign a piece of paper properly. That's what I'm saying. He just wasted the court's time asking, how do you want me to sign this? You want my copywritten name? My government name? At least it is. I don't even know what the other thing he said.
The bottom law might be wrong. It's been a while since I've read the Unified Court, but I believe this is right. I signed it for you correctly. So.
All right. Perfect. All right. If you give that to the jailer, Mr. Peltola, I want to go over with you what it means to sign that waiver. I know we've done this before, but I'll just refresh your memory. And let me start by saying, so long as you come back to court voluntarily for all your court appearances, this does not become
Okay.
relevant. But if you don't come back to court, let's say, for example, you stayed in Niagara or somewhere else like that, normally you're entitled to what's called an extradition hearing before you are returned to Michigan to fight the charges that you didn't come back to court for.
Yes.
Under an extradition hearing umbrella, you have the right to an open court hearing. You have the right to have a lawyer at that hearing. And if you're indigent or without funds, one is assigned for you. The purpose of an extradition hearing allows you to challenge the legality of your arrest and return to Michigan. For example, you could demand issuance and service of a Michigan governor's warrant for your arrest. You have the right to obtain a writ of habeas corpus. Like I said, all to challenge the legality of your arrest and return to Michigan. When
I
you
won't
sign a
resist,
waiver, what?
I said I won't resist, man. Never
All right,
mind.
I'm just
Go ahead, Your Honor. I
explaining.
apologize.
I'm just explaining to you what that document is that you're signing, okay, for the record, that's all. I'm not suggesting, implying, or anything else. I'm just explaining, all right?
Thank you.
All right, so when you sign that waiver, then what that means is, and like I said to start with, so long as you come back to court, everything is hunky-dory or everything is all right. But if you don't come back, when you sign that waiver, you have given up your right to that type of a hearing that I just explained. Do you understand that?
Yes, Your Honor.
All right, so that's what that means. So when I'm setting bond, I need that form back because I'm going to do the following in respect to your bond. And this can cover both the bond violation and the underlying charge of disorderly. All right, first off, you must sign a waiver of extradition as a condition of your bond. So long as you do, you can go back and forth between Michigan and Wisconsin for residency. Are there other reasons, Mr. Peltola? Do you work there? Do you have court appearances, medical treatment, family visitation, anything like that?
My family visitation almost every day, my mother, and I have
All right.
court issues that got pushed back, I believe like 5 months, 6 months, something like that. I
All
gotta
right,
find out
so-
the exact date on it.
Residency, court appearances, family visitation. If it expands beyond that, talk to your lawyer first, okay?
Yes, Your Honor.
All right, you are not to purchase, possess, or consume alcohol or non-prescribed controlled substances. You must submit to random PBTs and drug screens as a condition of your release. Don't go into
Yes.
businesses that sell alcohol for use inside, such as bars and taverns. Now, do you have a medicinal marijuana card?
I do not. I did at one time, Your Honor, but at the current moment, I do not.
All right, so for the moment then, both medicinal and recreational marijuana use and possession are prohibited until further order of the court. That changes, you make sure and get it to your lawyer who would bring the issue to the court if you got your card back. In regard to the matter then,
All right, I got a question. What's up, Mimi? Good to see you. I got a question. Now, sovereign citizens don't have driver's license, IDs. They don't believe in their whatever they're called, their name, the legal entity that is their name, the government name, whatever. Didn't yet they have a marijuana card with their name on it? Interesting.
stay off of the property of 1714 East 7th Avenue in Norway.
Yes, Your Honor.
Do not engage in any assaultive, threatening, harassing, or intimidating behavior towards any person while you are on bond. If you relocate for any reason, you must provide the court with an updated address and phone number within 7 days of any change. I am going to set the bond. All right, so you are in one of those unique positions, Mr. Peltola, where you have come before the court for your arraignment. Already behind you, or what you're being arraigned on, is both the underlying charge and a bond violation. So usually people will have an underlying charge and then whatever, week 2, 3 later, they come back with the bond violation. And when people are arraigned, I always give them a talk and tell them that if you come back with a bond violation, you're going to make it really hard for me to say, gee, I should let you back out into the community again. You, however, have not had that talk. You are having it today, and you are having it on both the underlying charge and the bond violation. So my pep talk is this, Mr. Peltola, I'm going to set the bond accordingly and give you the benefit of the doubt. But if you come back in here with another violation, I'm going to say, gee, Mr. Peltola, I had the talk with you and you went out and did the same thing I told you not to do. So I'm telling you, don't violate your bond and make me have a reason to keep you in custody pending resolution of your case. I'll set your bond right now at 1,000 PR. That's on both the bond violation and the underlying charge. They're going to let you back out, Mr. Peltola. Don't go back out and start drinking and do this again because, like I said, you'll leave me no choice. All right?
Oh, Your Honor, honest to God, I'm not even on drugs anymore. I wasn't sick. The only reason.
Hold on.
Nope.
I can see Miss Anderson almost doing cartwheels back there. She does not want you to talk until you have a chance to talk to your lawyer. Is that right, Miss Anderson?
That is correct, Your Honor. Thank you.
All right, Mr. Peltola, do you understand? She wants you to talk to your lawyer before you tell me anything, all right?
Yes, I understand, Ms. LaCost, or Judge LaCost.
Thank you, Mr.
Honor.
Peltola. We will see you soon. Your bond will come over, your writing dates, your lawyers. Make sure you call her when you get out and, you know, have a meeting with her. All right, Mr. Peltola?
Yes, Your Honor.
All right, anything else on this file then, Miss Anderson?
No, thank you, Your Honor.
All right, thank you. Have a good day, Mr. Peltola.
You as well.
Thank you.
All right, that was fun, right? Yeah, that happened. Lindsay Lou, welcome. Welcome. Good to see you. Glad you're here. And thanks for watching the channel over the last couple of days. All right, now we're going to Judge Washington, I believe. Got a Washington clip, then we have a Boyd clip, and then we finish with a funny one. So yeah, I'm pretty sure it's Washington next. So let's go.
Discussion of protocol case of the state of Michigan versus Sandra Law, case number 22-00563.
Richmond, Deputy for the People.
Assistant Public Defender Sandra White on behalf of Sandra Law. Can you state your name? Sandra Law.
Thank you. Good morning. You both may be seated. All right, we're supposed to be here for sentencing today, but it appears that this is Ms. Law's second time failing to make and keep an appointment. She asked to have her own assessment done, but the probation agent indicates that they don't see any assessment. Do you have that report and have you gone over with your client?
Yes, I got the report this morning. I did go over it with my client. And we do have something to say as far as the assessment.
You may proceed.
Ms. Law told me that she did do the assessment last week. She goes today to sign the paperwork.
Sign the paperwork to do a draft for them at 2 o'clock to start therapy.
And does a drop today, sign the paperwork, do a drop and start therapy.
Any proof that she's done this?
I called when I was on the phone doing the thing. She had me do a 3-way. I talked with Ms. Johnson and what's the probation officer's name?
Ms. Straub.
Straub. Got her email address and the address to the court for them to communicate. So she said, when I come in today, I have to sign some paperwork to allow you guys to communicate because of Information Act.
Ms. Straub's report does not indicate that. Ms. Straub, are you present?
Good morning, Your Honor.
Good morning, Ms. Straub. Ms. Law is indicating that she spoke with you and signed some
No, I spoke with
documents.
Ms. Johnson.
I'm sorry?
I spoke with Ms. Johnson and Ms. Johnson gave me her email address and the address to the court.
Ms. Straub is your agent.
Yeah, but I asked for her and I guess she wasn't in, so.
Ms. Straub, are you familiar with any paperwork from the assessor at this time?
I am not, Your Honor. I am aware of a phone call that she had with Ms. Johnson where she asked if she could perform the assessment with Hagira, but I'm not aware of any other information after that.
All right, we're trying to find a good place to pause it. David, welcome. Thank you for becoming a member. Welcome to the family. Philip Heels, thank you so much for the gifted membership, and welcome to all the new members. What was I gonna say? I don't know what is it. Oh yeah, McDuffie. Yeah, you can make an emo with McDuffie. That's fine. We can do up to 25 for now, and I think we only have 13 or 14 right now, so we still have room for about 10 more. JR, thank you so much for the gifted membership. Welcome. All right, let's keep going.
And she told me that was who she did the assessment with, Hagira.
Well, we have to have proof.
To can't verify anything.
That's not how this works, man.
I'm sorry. I did the assessment, I'll make sure it got done before court.
Well, it's supposed to get done and to us, so a report can be written to us before court.
Okay, I'm sorry. I can't control the way you've given you guys a report, but I gave the information man for the email address and the court address.
She says she gave that to Hagira, right?
Yes. So they could communicate with them. And they said, I need to sign for information X so they could communicate with them about therapy and everything else.
Oh, you had to sign a release.
I gotta do that today at 2 o'clock, yeah.
Okay.
That's what I'm going there for.
So we can't get anything if there has been no signed release of information. She's supposed to be here for sentencing.
Correct.
The recommendation is for a remand. I don't see any reason why I shouldn't do that at this time because I have no proof of anything.
Can we have a week adjournment so that she can get that stuff? Well, we're closed next week. 2-week adjournment so she can get that proof to the court.
Ms. McDuffie?
Your Honor, in addition to that, we're also here on a new bond violation. Ms. Law missed 4 more tests since her last bench warrant where she admitted to those missed tests. I think she had a surgery or something like that where that's the explanation she provided. These are 4 tests between January 10th and the 30th. And we have a positive THC, opiates, and amphetamines. That combination of substances has appeared from Ms. Law before. I don't know what prescriptions are on file for her.
He provided me with prescriptions today.
Yeah, her voice does sound like she's a smoker. For sure. I can see that. Also, Judge Washington, her face, she has a disappointed face during this entire hearing. And doesn't really move too much from that face right that we're seeing right now. She just the disappointed look. I couldn't look at her in the eye if I was in the defendant's position.
Well, first of all, you have to give this to the prosecutor before I'm gonna review it. So you should go to your office if you have a computer down there and make copies so you can provide a copy to the prosecutor. That's not how that works. I'm gonna arraign your client on her violations. This law, there's a bond violation report. Do you have a copy of that, Ms. White?
Yes.
Have you gone over that with your client?
Yes.
There's a bond violation report that indicates that you missed January 17th, January 24th, January 30th, and you had a positive THC, opiate, and amphetamine test on February 5th. Missing tests in and of themselves are considered a violation of your bond, at which time you could have your bond revoked. We've been doing this for quite some time now. And you test and do as you please. You are entitled to have a hearing, at which time if it is shown that you missed your test and or tested positive for THC, opiates, or amphetamines in violation of any rules, then you could be subjected to have your bond revoked. The documentation from community corrections does not show you provided them with any proof of your actual prescriptions. What would your client like to do?
Admit to the violations with an explanation.
No, well, right, but I'm not violating because I prescribed them, so I don't get it.
You're violating because you missed 3. At this point, you've tested 1 time in the past 2 months.
You're correct. Can I explain that or do I wait?
You wait.
And I have, proof of it too.
Yes, Ms. White, what would your client like to do?
We talked about this, but can we go out and talk about it some more?
She can go in the back. You can take her in the back, please. You can go in the back and talk to her about it.
Okay.
All right. It's gonna fade out in a second. There's about a 10-minute recess. Don't worry, we're not gonna wait 10 minutes.
Okay, I'm sorry.
Oh,
You want to leave it here?
I missed that part.
State of
All right.
Michigan versus Sandra.
All right, they're back. All right, before I go any further, Teresa, thank you so much for the $5 super chat. And congratulations on the job. That is awesome. I hope it goes well. And Trish, thank you so much for the gifted sub. And whoever got the gifted sub, welcome to the family. All right. Yeah. What do we think? Is she going to jail? What do we think? Is she going to jail? Yes or no? You can do one. No, I don't like doing that. I was going to say do one in the chat for yes, two, no. Or I'll make a poll. How about we just say if she's going to jail or not?
Case number 23-00563.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Ms. Law. Sandra Law, can you take your name again?
Sandra Law.
I left the paperwork in the office because I went back to talk to her. I'm so sorry. I couldn't get it to scan. I think I tried to tell Heather, but if we can adjourn for a couple weeks, I'll get everything sent over.
All right, if we have nothing today, she's gonna stay in custody.
Well, we have the paperwork.
No, I don't have anything.
Can we have her come back next week?
Yeah, from the jail.
Yeah, please say something.
You
ma'am.
didn't send over to the public department.
I sent it over to my other agent. He has it all.
She said,
And I did send it to probation, ma'am. I have a job. I just started last week. I'm done a very good path right now. Please don't put me in jail.
Ma'am, you're ordered to test,
Can I
and you are
explain?
not doing that. You haven't been doing it since you've been on bond,
Can
actually.
I explain, ma'am? Okay,
I'm sick of your explanation.
I'm sorry.
to be
I was
honest.
very sick. I have doctor's notes. There's doctor notes in there. I had surgery. They just took my other cast off and gave me a
she
removable
couldn't
cast
test because she had,
because this hand's paralyzed, so I
And-
couldn't drop with the other cast.
she just
So-
got a.
I'm sorry, what?
Okay, let me talk. She had a regular cast on. She just got a removable cast, so she couldn't test.
You can't test because you have a cast on your arm?
She said she had a regular
I
cast
can't
on.
cup, I'm sorry, ma'am, I can't cup the cup with this hand with the other cast on, and this hand's paralyzed. So they gave me,
Johnny, did you have to Google their names? If you would have just said the smoking twins from The Simpsons, I would have known who you were talking about. I could not have told you what their names were. Something tells me you just Googled their names before you typed that out.
a removable cast, and I talked to Mr. Levitt, and as soon as I removed it, I went immediately in and dropped. I've been good on my tether, I'm on a GPS tether, I'm not trying to run from nothing, I'm trying to clean up my life and get my life together. I got a real job, I'm not on Social Security no more. I didn't, when I did the assessment, I couldn't control the time frame that she got that into you. And then when she did the assessment over the phone with me, she was off work last week until today. So that's why my appointment is at 2:00, ma'am. I'm not trying to violate nothing. I'm trying to get my life together and do good.
They have hats that they use when people can't use the cup.
Well, they didn't say nothing to me. I asked Mr. Levitt if he could mouth swab me, and he said that's not what the judge ordered. She ordered urine test. I even asked, is it Lynn Schroeder? I even brought it to her attention, community care corrections. I called, I said, can they start mouth swabbing me, or can he come to my residence or whatever, so I don't get violated? And they said, no, the judge ordered urine screens. I inquired about it, ma'am. I didn't want no violation. I'm doing so good in my life right now.
Ms. McDuffie, what would you like to say?
So first of all, just so that Ms. Law is aware, I don't think she understood what the court just said. They have hats when you can't use the cups. A hat is a fairly large plastic, wider container that fits over the seat of a toilet so that there's no cup necessary and the urine goes directly there. We're still talking about urine tests, but that's
I
a
didn't know
device.
that. Tell me.
Ms. Law, Now is not a good time for you to say anything, plus I'm talking. That is something that they use when people aren't able to use the cups. I'm saying that just so that she understands what that is, what it means. Next. I don't know when Ms. Law was in touch with her tether agent. What I don't understand is how we managed to get a report from Agent Levitt, at least dated February 8th, that simply has missed tests, positive tests. Usually the reports that we get are pretty detailed with narrative if there's been communication with the defendant who's under a testing order when they say things like they have an issue, aren't able to test because of this reason. It doesn't say unable, missed, it just says missed. There's notes from fall of 2023 that have commentary about the things that Ms. Law explained to the agent and to community corrections regarding doctor's notes, not able to provide samples, car trouble, provided pictures of flat tire. But all of that evidence of communication is missing. All we have between basically then and now is just missed tests. It doesn't reflect any conversations with Agent Levitt. I'm not saying that she did or didn't, but I'm saying it looks awfully different from when we've had that evidence before. I don't know if she just contacted Agent Levitt today or in the last 2 days. I'm very confused about why there's proof of prescriptions coming in today. Again, I'm not speaking as to when Ms. Law contacted her attorney, but there's a whole lot of last minute shuffling of papers and things and explanations coming in when the consequence, she had a jail wreck, I think the last time. So Ms. Law knows that her history in this court with her extended failures to appear with the testing issues, Ms. Law knows that she doesn't really have any room to be making mistakes, and we all make mistakes and none of us are error-proof, but she knows that there's not any wiggle room here and that she's got to be in extremely good touch with everybody, with her attorney, with her agent, with the court, to do whatever she can to make sure we have all the information that we can get. I believe Ms. Law is having a difficult time. I know that she does have health issues, but I'm missing an explanation, and I can reach out to Agent Levitt right now. If I had known that we were going to come back from that breakout with no progress, I would have done it then. But I can reach out to Agent Levitt and ask him to pop in and tell us what he knows about this situation and if he's gotten any contact, at least since this report came out, for some clarity. But other than that, I'm not at a loss as to why we're here in this situation right now.
Can I talk, ma'am?
No, I was gonna ask if I may.
Okay.
If I may respond?
You can explain why we're in this position right now?
No,
Say whatever you want to say.
just that since I do have the paperwork, I would like a week for Ms. Law to stay out to get proof of the assessment.
I heard that part already.
Okay, nothing new.
Can I please talk?
I don't think we have anything new.
I do. I have an explanation for what she just said to me.
Ms. Law would like to make a comment.
Ms. Law, if you're repeating the same thing you said already.
I'm not.
Ma'am, don't talk over
I'm
me.
sorry.
If you're repeating the same thing you've said to me, it is only going to make your situation worse.
No, I want to respond to this lady on
If
TV.
it's something you've said already, it will only make your situation worse.
It's not, okay. When I called the doctor, nobody never told me about the hand.
Okay, you
or
did say
everyone-
that
but there's
already.
other
You said
things.
that
I have
already.
proof in my phone right now. You have to walk me out to the car. My conversations through email with Mr. Levitt, letting him know about me not being able to drop because of the cats and stuff. I did communicate. He did respond back. It's all through email in my phone.
Did the court want me to see if he can come run?
No, I don't. Thank you.
Mhm.
I could bring the phone in here. Of course, you can't run it.
All right, last shot. Is she going to jail or not? What do you guys think? I don't think I saw anybody say no. Everyone's in agreement that she's going to jail. I think I saw all yeses. What's up, Sobi?
This is what I'm going to do. I'm gonna adjourn this hearing until Thursday. I'm gonna give you a chance to get your documents in. It's not your fault that your attorney wasn't able to scan them and get them over to the prosecutor. If you don't show up here, or if you don't have proof, like you said you do, from Hagira, or proof that you actually have these prescriptions, I know there've been some in the past, I'm going to put you in custody, ma'am.
I understand that, ma'am, and I will have all of that. I'm gonna have them.
I'm no longer playing with you, Ms.
I
Law.
understand that, ma'am, and I'm there when I go today and sign the paperwork. I want to ask her to fax it right in front of me or email it, whatever she has.
Stop talking. You were just given the biggest break of anybody in any court that I saw today. Stop talking. You don't need to say anything else. If you have the proof, get the proof. She still has to come back on Thursday. So we'll see what happens on Thursday, and you know I'm going to be watching. But yeah, I'm very surprised that Judge Washington gave her 48 hours to get her proof together.
Doesn't do to probation. I'm not trying to hide nothing. And I will be here. I'm on a GPS tether.
2:15, 24:11 a.m. in person again. You need to be in touch with your attorney before then to find out whether you want a hearing on these things or not.
Okay, well, I didn't get a phone call from my attorney till the weekend, so I didn't know, and that's the only contact I've had since we've been in court on Zoom. Right back on, I told you I had all this stuff and I have a job and all that. And then you called me on the weekend. That's the only 2 times I've talked to you.
That's true. We'll see you on February 15th at 11.
Thank you. Thank you, ma'am. Thank you for understanding. And I didn't know because they did that when you couldn't bring your phone, so I left it in the car. But I keep everything for proof. Can you get my paperwork, please? Yes, I'm looking.
Yeah, no. That seems to be exactly what happened. The lawyer didn't get the documents to McDuffie in the court. And so she, because of a mistake her attorney made, she's given an extra 48 hours. That's an interesting tactic. Now, I'm pretty sure if she was caught doing that on purpose and they can prove it, there'd be sanctions. So that wouldn't be a thing, but interesting thing to keep in mind. Okay. Let's see. Where are we going now? I said it earlier. Oh yeah, Judge Boyd. I don't play Judge Boyd a lot. Yeah, I just kind of stopped watching her court, but I was watching a little bit this afternoon and I got a good one. This is a really good one. All right. Okay, I'm caught up to date on Super Chats. Okay. Let's go.
CR 8667, State of Texas versus Leonardo Carlos. Can I have parties announced for the record for the state?
Daniel Escobar.
Defense,
George Sharman on behalf of Ms. Carlos.
are you Mr. Carlos? Counsel, have you received all the discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Carlos, did you review the document entitled True Bill of Indictment with your attorney?
Yes.
And did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are good.
Showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it?
Yes,
Did you
sir.
sign it?
Sure.
Showing
Oh, you already know. When I get court cases that have follow-ups, so I jump all over them. Follow-ups are generally not as interesting as the first one, though. You know, her attorney's going to say, you got to calm down. You talked way too much. Don't do that again. So it's always a little bit, it's never as intense as the first one. But you know what? Follow-ups are still nice. So yeah, I'll definitely cover it, whether or not it's interesting or not, whether or not she goes to jail or not. And about this clip, this isn't a defendant that is the issue. It's Judge Boyd and the attorney kind of get into it.
you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney?
Yes, sir.
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has,
Do you believe he has a rational as well as a factual understanding of the charges against him?
yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
Yeah.
Mr. Carlos, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Yes, sir.
Anyone promised you anything other than the plea?
No, no.
Satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $500 fine. State recommends community supervision. This will run concurrent with County Court Cause number 710098, 71099. Take in consideration 2023 CR 6643. County Court Cause number 713955, 713958. Ignition interlock for half the term, victim impact panel, and DWI intervention. Did you understand that to be your plea?
Yes, sir.
Defense, is that the plea?
the plea includes, an option of either 10 years, jail, 10 days jail.
That's outside the plea bargain agreement.
It's in our plea bargain.
No, it's outside.
It is part of our plea bargain.
What I'm telling you, counsel, is this is your plea bargain agreement. This is outside the agreement.
Well, it is my understanding it's part of our plea bargain.
All right, I'm telling everybody, it's not a part of the plea bargain agreement. Note, this is what it reads. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and condition of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea bargain agreement. However, the state or both parties make the following non-binding recommendations. And what it says is 5 years community supervision, TAP evaluation, 120 hours of community service restitutions, 2-year driver's license suspension, 10 days house arrest in lieu of 10 days Bexar County jail. That's not a part of your plea bargain agreement. You all can present that to me and I can either follow it or not follow it, but that's not a part of the plea.
Is the 5 years probation part of our?
No, it is not. The court
So-
determines the length of a probation.
And if you reject that 5 years, then it's a rejection of the plea bargain agreement.
No, if I don't follow your length or your suggestion for the length of probation and I give you, let's say I were to give you 8 years on probation or 4 years on probation, that's not a part of your plea bargain agreement and I have not violated your plea bargain agreement because the court determines the length of probation, not attorneys.
Then Judge, I think we can't go forward with this because our understanding of what a plea bargain agreement differs.
All right, well, what I'm telling you all, according to the law, you cannot come before the court and tell the court, I want to be on probation for 5 years only. Y'all are not allowed to enter that agreement, period.
Now, Judge, you do not have to follow that agreement. That is correct.
That is not a part of your plea bargain agreement, counsel. The court decides the length of probation that somebody is on. The attorneys do not. The attorneys just make a suggestion. I'm going to read it again. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and conditions of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea bargain agreement.
Is probation
then-
part of the agreement?
Yes, they're recommending probation. Now, if, for example, if I were to say, okay, you guys have agreed that he's to have probation and I say I'm not giving you probation, then I will have violated your plea bargain agreement. But the length of time, the conditions, that's completely up to me. You all can't enter into a plea bargain agreement telling the court what your conditions will be.
That is not my understanding of the practice in this county.
Well, if people are practicing that different in this county, and no. don't want to be mean to anybody, but if people are practicing that differently, then they are practicing the law incorrectly because the court decides the length of probation. Nobody else does. Defense attorneys don't decide the length of probation. The state doesn't decide the length of probation. The court does. Nobody else does.
Well, I guess my concern is moot at this point unless you do not follow our agreement.
Well, the question becomes, what do y'all think you have agreed to? Because if you think you've agreed to how long he's going to be on probation, that's not a part of your agreement. So if you all want to reread your contract, you're more than welcome to reread the contract. If you all want to go forward, you can go forward.
Well, Judge, I guess I need to review that comment
Sure.
and we'll come back to it.
All right. And State, if you want to show him.
Words based on the court's understanding.
No, based upon the law, councils do not get to determine the length of probation or the conditions of probation. That's not my understanding. That's the law. If people want to get that law changed, they need to talk to the legislature.
Well, it's been my understanding and the practice in this county that the judges.
Oh my God, dude, stop. He's repeating the same thing over and over again. You know, it's like the last defendant that we were listening to make the same excuse over and over again. It's not going to help you. Judge Boyd already said no. That's not how it works. It's like, well, this is my understanding. Well, I'm telling you, it's wrong. But this is my understanding. Okay, well, it's wrong. But this is mine. Okay, dude, just go sit down, have a juice box, get your blood sugar back up, come back up.
Well,
To do that.
well, I don't want to disparage any judge, but guess what? They're wrong. Because according to the law, according to that document that y'all just signed, the court determines the length of probation. Nobody else determines the length of probation. The court does. So if the state is asking for 8 years probation as the length, I can say, you know what? I've read the facts of this case. I think the person should only be on probation for 4 years or 3 years. That's up to me. Or the state may say, me and the defense counsel believe the person should be on probation for 5 years. I may read it and think, no, that person should be on probation for more than 5 years. I'm allowed to do that. And guess what? That is not going against the plea bargain agreement that you've entered to. So if y'all want to discuss that, you can. But if other judges are saying, oh, the law is that's the plea bargain agreement, then those judges would be wrong. All right. Yes.
I'm not ready to go forward with it then.
Then we'll be in jury trial. All right. Macy Malone.
Present.
All right. So did they give you, and if you want to hand that back. So jury trial is at 1:30. And you can put that in here. And
all right, they come back up. That was the painful part. Now we're going to go through the boring part where he accepts the plea deal. So I wanted to keep this in here. Just, he does come to a sense of, but I also want to say, I've heard this from multiple different judges. Some judges put it as part of their speech when accepting a plea deal. They say, I don't have to go by the terms of this plea deal, but if I sentence you to something that's not in this plea deal, you have the right to withdraw your plea. And that's in my understanding, that's how it works. So even if whatever is on the paper that he's talking about is the amount of probation he's going to get, I don't know what it is. I don't know what the crime is. Let's say it's 1 year probation. And that is in the guidelines. So that's what she's going to give him. That could still be the case. But if she gives him 2 years of probation, he can withdraw his plea and, rework it or go to trial for it. Anyways, that was painful. I know. And now we're going to watch the boring court stuff.
Could I have parties announced for the record?
Oh, also, before I forget, thank you so much, Tupac, for the $10 super chat. Yeah, I would love to interview Judge Webster. I've got a couple others that I'm working on right now, and I don't want to ask too many at once. Just, for the rare possibility of, 3 people responding yes at the same time, I wouldn't know what to do. So once I get a solid yes or no from the couple that I've asked, I'll start moving on or scheduling my next interview. But yeah, thanks again for the super chat.
For the state,
Daniel, Spark, State of Texas.
defense.
Sherman on behalf of the defendant.
And are you Mr. Leonardo Carlos?
Sure.
Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Sure.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $500 fine. State recommends community supervision. This will run concurrent with County Court Cause number 710098, 71099, taking consideration 2023 CR 6643. County Court Cause number 713955, 713958, ignition interlock for half the term, VIP, and DWI intervention. Did you understand that to be the plea?
Sure.
State, is that the plea?
Yes, Judge.
Defense, is that the plea? Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Sure.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sure.
Counsel, have there been any such motions?
No.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 120 hours of community service restitution, 2-year driver's license suspension, 10 days house arrest in lieu of 10 days in the Bexar County Jail. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State officer, State Exhibit 1 and all attachments.
Any objections?
No good.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Sure.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Sure.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Sure.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Yeah, Judge Bryant would be a fun interview, but I would be terrified to even ask her. She does not like YouTubers covering court. So I wouldn't, I would just be terrified to even ask her. Put my name on her radar. I'm going to avoid that at all costs. Also with Jay Regier, I don't remember how long ago this was, maybe 6 months ago. Law Talk with Mike said in a live that he reached out to Jay Regier hoping to get him on, and he never heard back from him. So if Law Talk with Mike can't get Jay Regier, I think that's a lost cause. I don't even think it's worth attempting. I mean, I could, but I could try, But yeah, I don't know. Also, Jay Hart, thank you so much for the 3 months. That's awesome. You're one of 5 or 6 that have more than 2 months. Thank you so much.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Well, you had an ignition interlock on the car?
Okay, you're all going to have to speak up so that the court reporter can hear.
And have you been abiding by the conditions of bond and
Yes, sir.
not drinking alcohol?
No.
You want the judge to grant you probation or to continue you in with the ignition interlock for 1/2 of the time?
Yes.
All right, do you have?
Ed, that is actually a really good idea. I didn't think about that. That would be That would be a nice change from yeah. Thanks for that idea. If I do go down that route, I'll definitely give you a shout out.
Any children?
No,
Are you employed?
yes,
What do you do?
electrician,
And how long have you been doing that?
about 10 years.
All right. Do you own your own business or you
No, I
work
work for a
under?
company.
I'm sorry?
I work for a company.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 5 years in the prison, suspended and probated for 5 years. There's a $500 fine. That will be probated. This will run concurrent with County Court Cause number 710098. County Court Cause number 71099. Taking consideration 2023 CR 6643. County Court Cause number 713955. 713958. There's to be ignition interlock for half the term. VIP live. DWI intervention. DWI education. 2 years driver's license suspension. 120 hours of community service restitution. You can either do those hours or pay them off at $7.25 per hour. There's going to be 90 sober meetings in 90 days. With regards to the Bexar County Jail or GPS, one or two ways. Either you can go to the Bexar County Jail, do your 10 days, or either you will be on GPS for 30 days, partial for work, and it will
Yeah, James, I've actually been trying to do the 8 o'clock slot. I think I've been pretty consistent about doing that over the last couple, at least probably the last 2 weeks. Pretty much been consistently 8 o'clock, and I'm liking this time, this block. Last night it was at 8:30 because that's when Judge Slavin was available. But other than that, yeah, I think I'm going to stick with this 8 o'clock slot for the time being.
be only for work. Or either if you don't want to do work, you can be on full house arrest for 20 days. Which do you prefer?
I go to work, back to
All right.
GPS.
So because of you, it appears you have on a mask.
Yes,
So because of health issues at the jail, the court will grant you to do 30 days GPS partial for work. That means you can only go to work. There's no stop to the grocery store or anywhere else or relatives' home. You
yes,
understand?
I'm on GPS right now.
Okay. So 30 days GPS partial for work in lieu of the Bexar County Jail. There's to be regular reporting by Zoom or in person. There's to be regular UAs. We can do a TAP evaluation out of custody and a referral to felony drug court. Field visits 1 time per month for 4 months. And then at probation's discretion. Probation, is there anything else he needs? Thank you. Proof of employment. Within 15 days, there should be no employment as a home health care provider or with minors.
Judge, after the 30 days, can he remove the GPS monitor?
Yes, it's only for 30 days.
He has it on there.
All right. Is there anything else, probation? Is there anything else you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, if you'll step back a little bit. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. In this court, communication is key to be successful in probation. If there's an issue, let probation know. If you feel like they're not addressing it, you can always come back to the court. Do you understand?
Sure.
All right, good luck to you.
Thank you.
Thank you. And Norma.
All right. Yeah, Badass Momo. I hope the little one recovers quickly and yeah, get yeah, I'm not good at saying these kind of things, but keep us updated on the progress. Let us know. The one thing I do love about this community is we're all adults. Most of us have kids or even grandkids, so we're all with you. We're all on your side. We're all thinking about you. So keep us updated. The next time we see you, let us know the progress. All right. Let's see. We're going into the last clip of the night. It's a shorter one. It's only about 5 or 6 minutes. So I'll probably just pause it once halfway through just to keep YouTube happy. And I'll say my goodbyes then. But everybody, thank you for coming. Thank you for the super chats, the new memberships, the gifted memberships. You guys are all awesome. We, as always, will be hanging out in Discord after this. And if you got next time you guys see Heather, thank her for all the cool emotes. I know Rich is working on some as well. So those two have been awesome, helping me create stuff for the channel. Because I do not have the artistic thing in me. Even if it's just cutting a picture of a judge and making an emote out of it, you don't want to see what mine would look like. So yeah, I'm very happy to have both of them in my corner helping me. All right. Yeah. No, one pause. We'll get one pause. But yeah, I think that's all I got. As always, if you guys really love this video and you want to bypass the YouTubes, my link tree is in the description. It helps me out a lot because yeah, YouTube doesn't take anything for it. So if you want to do that, I would very much appreciate it. Please and thank you. All right, let's go. Oh, I also should say I cut out all the boring parts of this clip. So all of the basic court procedural stuff coming up to this part, really it was just cut and paste. The judge was just reading everything. But the ending is kind of humorous, so that's why we're watching the ending. All right, now let's go.
I do, Your Honor. As to counts 2 and 3 for assault, resist, obstruct a police officer, how do you plead?
Guilty, Your Honor.
As to added count 4, use of the controlled substance methamphetamine, how do you plead?
Guilty, Your Honor.
Now, before the court may accept your guilty plea, I must have you tell me what it is that you did that makes you guilty of those 3 offenses. Turning your attention to January 4th, 2024, here in the city of Cadillac in Wexford County. What happened?
I got pulled over. I was with a friend, and upon getting pulled over, I exited the vehicle and tried to run, and I was tackled by a trooper, and I was under the influence of methamphetamine when that happened.
It's about to go down in a funny way.
Okay. So when you were pulled over, I'm going to ask you some questions which seem very obvious, but I just want to make sure I'm making a complete record. You were operating an automobile somewhere in town?
I was not operating, I was a passenger.
All right. And did you see that it was a law enforcement officer pulling the vehicle over?
I did, Your Honor.
So that officer must have had a patrol vehicle, a marked patrol vehicle, and wore uniforms. Is that right?
Yeah, sure.
And then you said you got out of the vehicle and ran. How far away did you make it before trooper shots tackled you?
An embarrassing amount of space, Your Honor.
All right. I chuckle because Trooper Shantz is at least 6.5 foot tall. So
yeah, he's pretty much Megatron.
All right. And with him, was there also a state trooper, a cadet, another officer?
There was, Your Honor.
And before you took off, or while you were attempting to flee?
All right. That was pretty much it. I just laughed at that. How far did you get? An embarrassing amount. You pretty much tackled me right when I started running. Megatron. It made me laugh. It was funny. Also, on another note, I've explained this multiple times, but on the StreamYard part of things, I don't see the emotes when you guys put them in. It just comes up whatever they're titled. And I've been trying to figure out what IATGD means for the last 20 minutes because you guys keep doing it. I'm like, what does that mean? And then when I said it's about to go down, and then you guys were all doing that, I'm like, oh, that's what it means. I didn't realize it was titled just abbreviated. All right. I'm gonna let this play out now. You guys are all awesome. Thank you so much. Come hang out with us in Discord after this. And yeah, until next time, which will be tomorrow. Bye.
They yell stop or anything else to that effect?
They did, Your Honor.
All right. And you said that you had been under the influence of methamphetamine. Did you have any lawful right or reason to take that methamphetamine?
I did not, Your Honor.
And when you used that controlled substance, did you know that it was, or whatever it was, contained methamphetamine?
I did, Your Honor.
All right, thank you. Mr. Wiggins, do you believe the defendant has provided a factual basis as to counts 2, 3, and added count 4?
I do, Your Honor.
Ms. Ruffalo?
Yes, Your Honor, I do.
And Mr. Wiggins, do you believe the court is, I'm sorry, I went off my script. Maybe I should do that just to throw a little wrench in it. I like to mix it up once in a while with Mr. Wenrick to make sure everybody's paying attention. Do you believe the court's compliance? Do you believe the court's compliance with Michigan Court Rule 6.302?
Yes.
Ms. Ruffalo?
Yes.
And Mr. Wiggins, are you aware of any other promises, threats, or inducements?
I'm not, Your Honor.
Ms. Ruffalo?
I am not.
The court agrees and finds the defendant's pleas today are made freely, knowingly, and voluntarily. The court further finds that the testimony provided today under oath on the record by the defendant satisfies the elements for counts 2, 3, and added count 4. Therefore, the defendant is found guilty of those 3 counts. Count 1 and the sentencing enhancements will be dismissed at the time of sentencing. Mr. Winrick, as you may know, a pre-sentence investigation report must be prepared at the time someone's convicted of a felony in this courtroom. That report is prepared by an agent of the Michigan Department of Corrections, also known as the Probation and Parole Department. That report will include a description of the offense, description of the pretrial agreement, any statements, information you make or provide, as well as information about any prior criminal history you may have. It will also include a scoring of the Michigan sentencing guidelines and make a recommendation as to the sentence. I note that it is merely a recommendation, as it's the court that determines the sentence. There are 2 steps in the preparation of this report that involve you. First, you will receive a packet of information. You will complete that packet and turn it back into the Department of Corrections. Second, you will be subject to an interview with an agent from that department. And of course, you have the right to have your counsel present at the time they conduct that interview. Next, each party will receive a copy of this report prior to us coming back to court for sentencing, and I trust that Ms. Ruffalo or someone else from her office will come and discuss it with you. Each side has the right to come back to this court, make objections, request corrections, or amendments to the report prior to the court giving a sentence. Do you understand so far, Mr. Winrick?
I do, Your Honor.
All right, good. Anything else, Mr. Wiggins?
No, Your Honor.
Ms. Ruffalo, the court's going to revoke bond, remand him to custody of the jail.
Thanks, Jay Hart. I appreciate it. And she'll appreciate it too.
I'll give him the greatest chance of earning credit for the time that he's sitting at the very least. So, all right. Anything else, Ms. Ruffalo?
No, Your Honor, thank you.
All right, Mr. Winrick, thank you very much for your time, sir. We are adjourned.
Thank you, Your Honor.
Yep.